Boa tarde a todos.
Good afternoon, everyone. It's a pleasure to be here to start with this table. That's the 8th Forum of Taxation, sponsored by the IBDT. It's an honor to be here with you, with experts, and I am pleased to be with Ms. Misabel, Derzi, Alexandre, Luiz, Tathiane, Piscitelli, Heleno, Torres, Vanessa, Cecconello. The theme, resolving international tax law conflicts. The view is here. Brazil, conflicts in taxation, innumerous. We have a big amount of them. And sorry, it's difficult to hear. I'm trying my best. The translator is saying. Okay, when we have taxation processes that include, it may normally it's 12 months, 11 months, and the subject here, it indicates that what's the most important to solve concerning taxation would be giving a forward way to our decision making in this sense. Obviously, our focus is the international law, and so the principles I'm trying my best to do the translation, but the sound that is arriving here is impossible to go well. There is a lot of missing words. And so we have here the persons that already have been mentioned that I can read. We have Mrs. Vanessa Cecconello, Misabel, Derzi, Alexandre Luiz Moraes, Tathiane, Piscitelli, e Heleno, Torres. And with the CVs of the persons are being read. Alexandre Luiz Moraes Monteiro, pela NU e doutor em Direito pela USP, que toda a sua prova examinadora, e a Vanessa Cecconello, que é mestrando em Direito Tributário Internacional e Desenvolvimento pelo IBDT e vice-presidente da terceira sessão da Vanessa. I will pass the word to Vanessa and also I'll solve the problem while Vanessa is talking. Okay?
Obrigada, professor Paulo.
Okay, lovely. Thank you, Professor Paulo. I thank IBDT via Dr. Luiz Flávio Neto, professor, and our panel will be, as has been said before, dealing with this theme that is resolving international tax law conflicts. The points we focus on in this analysis are juridical or legal safety, and concerning the experts or UN, the thoughts they have, and also taxation arbitrage, which will be exposed here. And we will also talk about MAP. It's a mechanism that is foreseen in this taxation panorama, and we will present the situation in Brazil concerning our treaties. And after saying that, the themes that are very important and so many, I pass the floor to Mrs. Isabel, that will be the first talk. Okay, the discussion concerning legal certainty will be part of this roundtable. Isabel is saying, I'm pleased to be here in AIDS Forum, and I greet via the president of this panel, Professor Paulo Ayres, all attendees that are here, and also Dr. Professor Vanessa Cecconello, and others that are speakers, the others that are part of this roundtable. My theme specifically is focused on the different conflict resolutions or solutions from the point of view of legal certainty. That's the big theme, looking for more transparency in companies and facing the profit shifting, base erosion, and other problems. And national companies and multinational companies are concerned about the costs in terms of compliance and situations of multiple and double taxation. In this context, legal security with its several folds involving transparency, forecasting, taking more and more and calling more attention from international agencies and mainly concerning OECD. Some aspects not always are dealt with, but they are very important, like consistency and coherence in administration procedures from the part of the administration in terms of taxation. So it's very important consistency to guide the performance of the multinationals and in an international scenario. So we have several mechanisms over the last years that are cropping up in order to promote exactly that, more security, forecastability, and the administration of the risks, and also consistency and reduction of costs. Briefly, we will present the different methods, the additional ones, the recent ones concerning security. Therefore, the previous agreement concerning transfer price being binding from in case of the involved parties, it will bring more certainty for the taxpayers and forecastability in future cases of dispute. So, i.e., we based on security, certainty. Some companies, some countries adopt methods frequently when it refers to EU. We have several aspects being discussed, like the cost of compliance. Mainly, they set together the taxation administration of different countries, and it helps us, it brings more confidence. So, in a normally, if you do it in an amicable way, it generates affirmative results. So we have common disputes, we have taxation disputes between states, and we know that the disciplinary mark 25, for instance, we can read that you can adopt arbitrage when it's not well succeeded. Arbitrage normally has effects that are uh, that are post case and is defended by OECD. It brings controversies, mainly in countries that are developing countries, exactly because of the issue concerning lack of security and lack of confidence. Of course, we have to leave very clear that Brazil does not adopt yet domestically arbitrage as a solution for controversies in taxation, despite the fact that there are hurdles, legislative hurdles for that. So not having confidence, not concerning several methods in judicial decisions, it reaches the domestic environment concerning taxation per se. Even domestically, we cannot do it because there are obstacles, there are hurdles, and we would not raise the subject here because we can only refer that it is linked to arbitrage. And it's important to pinpoint the lack of confidence, the uncertainty, and the issue of lack of security. Even then, this binding that should be presented concerning the arbitrage ruling, it would be the, in this case, the award would be in the area touching other rules and regulations that are more adapted to regulating arbitrage to offer more security in the taxation field. So in case of internally resolution modeling, it's always suggested, they are always suggested, looking for legal security and confidence generated by state acts. It represents instruments of a culture like the Brazilian one. We have a strict taxation legislation. And so, and above that, we have a very prevalence, we have a prevalence of many, many regulations in this area. And it's a very sophisticated with double or three times folds in terms of guarantee, in terms of judicial and complex rules, judicial rules, that despite all that, we still have, moreover, concrete cases and similar cases, the abstraction, general abstraction, something that is inevitable, the control of laws that are abstract, similar to the European one, living together and simultaneously in Brazil with the control that is subjective, like the North American rules. And sometimes about the same rule, we have both of them. And in countries like Europe, and generality and equity to be with the prevalent binding, the particularity of arbitrage in this case, is a result of receiving it in Brazil the way we are. We have many, many legislations, but they're not enough. It couldn't be the other way because we always have very long discussions, judicial discussions, legal discussions. Uh, Even in more concrete cases, we have arbitrage like an ordinary technique to solve with the concept that the preceding judicial rules in an horizontal way, we cannot say that the judges in this case, we cannot simply dedicate pertinence, coherence to the other already awarded cases. So these are some of the problems that we have domestically. So the difficulties concerning arbitrage, it's very vast, very strict. But even then, in international aspect, there are difficulties to adopt arbitrage in Brazil, bearing in mind that Brazil, however, has been following the international treaties. For instance, the traditional international code concerning taxation, with following the treaties internally, and they will be observed concerning the examples of European standards. And we are recognizing the efficiency of it. Compliance cooperative is another method that is being used. It's a relationship that is was established some time ago concerning strategies, contemporary strategies, especially concerning the adoption of a control taxation framework prepared and preparatory. It's a consequence of a process that started in 2018 and about the initiative of the ECD in this line, there is a process that is multilateral and cooperative, assuming some issues that refer to risks, which is of interest of multinational companies. It has been opened, and it was not open to every segment concerning taxpayers, but some multinational only have access to it. And it is the version one, and there are two sectors concerning transfer price and identification placing of profits involving permanent companies. Let us say, at the end of the process, these companies receive the taxation administration receives a letter with the classification of the risks. Is it enough? No. Uh, you can find, for instance, high risks concerning transfer pricing and adopt a previous agreement, a lateral map, and close that the process of GAP. In version 2, 2019, there was the adhesion of 10 new countries and the expansion of the themes to be analyzed with a final forecast concerning resolution of problems and the risk evaluation. In this version, too, besides the transfer prices and the established companies concerning taxation issues in multinational companies, solving the processes. Comparing the new and the old instruments, in summary, Professor Tarcísio Magalhães has said concerning legal security or certainty, the previous agreement concerning prices guarantee total certainty for the future. The auditing and the amicable process and arbitrage processes promote certainties only with retrospective, backwards. The idea of the new processes called ECAP, it's intermediate because it permits the parts can work in cooperation to reduce the excess of disputes ex ante. So there is mitigation, sorry, and providing a reaction and negotiation ex post. So we have a series of measures with the methods focusing more security, more transparency, and more certainty. Old methods remain. They exist, but they are only complementary to look for the uncertainty and security. So the procedures that are amicable and traditional, arbitrage and auditing, we also have other processes that are new and they view not only prevention and also solve litigation and negotiate future litigation. In the perspective of the taxpayers, the CARF can be seen as something revolutionary and would help the improvement of the risk profile, reducing costs of compliance, and just following the changes concerning the digital economy. Ladies and gentlemen, thank you. After the world of post-BEP, the digital economy, it's a globalized economy, so we have many variables available. They are not under control. It's a post-pandemic world. We have for sure the certainty that we do not control, not even the variables of the auditing. So more than ever, these methods of conflict will be reviewed, and all of them will be looking for more confidence, good faith, and legal security. Thank you very much.
Muito obrigada, professora Misabel,
Thank you very
pela
much,
excelente
Professor
explanação.
Misabel, for the
E
excellent
terminando aqui a
explanation.
análise
And
desse
within this
CARF,
issue of checking
esses métodos
legal
CI,
certainty in this method CI, how can we conciliate this resolution of conflicts with this legal certainty? I pass the floor to Professor Heleno to deliver his words regarding BEPS and the experience on the UN Experts Board. Thank you very much, Vanessa. I will ask you to, if you could introduce, do my presentation. Thank you very much. Thank you. Beforehand, I would like to congratulate my dear friend, Professor Misabel Derzi, for the fantastic introduction, placing all the bases of issues related to dispute solutions for tax matters, and also saying how pleased I am here, or I'm with Professora Tathiane. No doubt it's a professor that has done an important work of international integration, several subjects, especially in these for solving international tax law conflicts. No doubt, together with our dear Vanessa and Professor Ayres Barreto, my dear friend of department. So I'm very happy to be here with all of you. And obviously, but not less important, my dear friend Alexandre Moraes. I'm happy to be in the same panel to deal with this important subject, which is solution of tax law conflicts solution or resolve it. With Action 14 of BEP, several debates regarding the optional means for controversy resolving and agreements to avoid double taxation in face of the importance that this subject imposed for the legal certainty, forecastability, and legal security at large, but obviously we could not at any time talk about tax, international tax. To go deeper in the whole debate regarding this huge subject with is resolving international tax law conflicts. So this subject came in Brazil for a long time, was just lined by those fields of administrative procedure or judiciary procedure. So duality of doors for the judicial administrative field forge the tax model of 20th century and obviously the first decade of the 21st century. As of the second decade, we saw a strive by the doctrine, especially regarding by the legal system, to find options for solutions and conflict solution extensive to tax law. So those past limitations, as Professor Misabel mentioned, concept of tax credits and non-availability, non-tax strongly rooted by a legacy that's exacerbated. So it makes no sense now because we understood its reach and especially multiple possibilities that one has for optional methods of conflict solution. Now, of course, I don't want to delay longer on mutual agreement procedure because Alexandre will deal timely with it. Nevertheless, one knows that for a long time, Brazilian conventions for conflict resolving, they always, as the others, encompass this method of conflicts resolved with no practical use. We could count in one hand fingers those cases that by the end of the first decade of the 21st century were deemed as debates within the inland revenue. No one has reached a definitive solution. Some attempts happened of agreements, mutual agreements, but no outcome. This was the picture of conflict resolving regarding treaties and conventions to avoid double taxation in Brazil, based normally on Article 23 for some cases, and for Brazilian treaties, the case is Article 25, as commonly we see. And these methods for dispute resolution, they were not, you cannot use them. So it prevailed measures by the administrative procedure, ordinary fines, and followed by taxpayers' expression. And with this, it reached CARF within the administrative scope and the judiciary level regarding legal authorities. Few went this path, not taking into account this clause in mutual agreement and friendly resolution. So this model of MEP, not going to courts, in the old model did not prosper in Brazil, but recently we have seen some cases, and Alexandre will deal with these aspects. Perhaps he will do it in a detailed way, but we have seen during the last 5 years on OECD, UN, and European Union, a strong movement to include the procedure of arbitrage within the MEP. So this new models to try to solve disputes in international taxation, no doubt the biggest challenge at the moment for tax authorities of the different countries. So, nevertheless, of course, because it's quite recent, we don't have a consensus amongst OECD, UN, G20, or even the experts committee of UN that's still looking at this subject regarding the model of tax arbitrage to be applied as a mechanism for dispute resolution regarding those involving cases whereupon we require the enforcement of clauses of agreements to avoid double taxation. Within this line of tax arbitrage, several proposals are being made, several models are being submitted. No doubt the UN is heading this, and we will talk a bit further about it. But in fact, what all expect is to that we have by the end of the arbitrage procedure to have an order that is efficient, it's binding, to enforce in both member countries of that convention. Of course, the convention must confirm an effect in such a way that it's binding, effective, in order that the award by the arbitral court can place the administrative procedure to its content. So here we have the main challenge, bearing in mind the many nuances of legal systems involved. Not all have laws ruling over laws or setting forth about arbitrage and to solve disputes. Other apply but don't accept the extension due to public law. Other does by public law, but only for entities of the state. So these are issues that still are being developed within the scope of several countries. We have now some countries that have adopted some measures like Australia, Austria, Belgium, Canada, France, Germany, Italy, Japan, and Poland, Sweden, UK, USA, some agreements to avoid double taxation. And it shows in map the possibility that involved authorities will action the arbitrage procedure as a way to solve disputes. So, as for UN, since 2017, I'm part of this experts committee as a consultant of Brazil in this specific case. We have an academic debate in this specific case of the experts committee for international cooperation in tax matter, I'm sorry. Several studies regarding these measures for dispute resolution. And the manual that's being prepared to guide member countries of the UN, especially here, we are talking about, especially about those countries that have taxation based on prevalence at source. These are poor countries that are not members of the OECD that use the political capital of UN as a way to ensure a relation of resistance to certain measures that have the interest of transferring the income to resident states. This is a logic that today we cannot say that there are conflicts. In fact, we have an attempt of conciliation of both lines dominating UN and OECD. Of course, here within the scope of this debate, no doubt on the fifth chapter, map including arbitrage also. Now, in this last section of the current year of the experts committee, we had a guidance which it was very straightforward in order to propose within this change the introduction of arbitrage binding as one of the ways to map of enforcing map to agreements to avoid double taxation that can be executed from now onwards by the countries of Latin America, Asia, those countries that don't adopt in a strict binding way the agreement of ECD. But as I said, this is a way of seeing things. In fact, countries today, they sit down at the table with both uh, models, UN and OECD, and they try to reach an agreement and synthesis with both ways of doing things. So at the UN, we have the Directive 2017-1852 that reached several cases of income taxation, like those of triangular cases, subcapitalization, and so forth. And here, of course, this directive has a clear reach, which is sets forth the use of our tax arbitrage in the resolution of disputes involving international treaties amongst member countries of the European Union. In this sense, mechanisms for dispute can that taking into account the interpretation and enforcement of conventions to eliminate double taxation over capital and income, in fact, can use by binding force of the directive the tax arbitrage. So, Article 6, we have a commission, and of course, this commission with the arbitrage court takes a group minimum of 5 and maximum 9 members with the commission, specific commission established, and this group will go to, based on the moment that there's the possibility of establishing a friendly procedure based on arbitrage, these countries can use arbitrage. There's the advisors commission is it has 50 days approximately to install this arbitrage procedure, and following Article 8, we have the composition of the commission, a chairman, representative of each country, at most two per country, an independent authority for each country. And then costs we have here, of course, competent authorities, they will search for dividing amongst them the costs of cases, and also there are exceptions. This division, equitative division of values and amounts, and also there's the remuneration of those independent, limited to 1,000 euros per day per person. Professor Heleno. Yes, we are concluding. Thank you very much. Well, by the end, we have this an award binding for the member states, and we have therefore one more aspect to be mentioned, which the final decision shall not be a precedent to bind other assumptions. Well, we have arbitration in some treaties. In Brazil, I'm sorry, correcting, he's correcting. There's no international agreement that includes arbitrage as a dispute solving method. And also, we are searching for in-house this possibility. And in Brazil, according to Law 13.988, we have the introduction of tax transaction. It's a way with no limits. It can be employed to agreements to avoid double taxation. There's nothing that will prevent it unless, and it has and it has to be under the protection of judicial and administrative procedures. And following also, we have in Brazil arbitrage regarding public administration, either based on law 13, I'm sorry, point 129, or the chambers of conciliation of the AGU. And last year, more than 5 billions were subject matter of dispute on arbitrage and conciliation chambers by public authorities. And now we have two bills underway on tax arbitration. One is PL 4257/19, and a recent one is PL 4468/20. Both bills, we have the possibility of creating tax arbitrage underway. Senator Anastasia, Congressman and Congresswomen Avi Ribeiro, it's under discussion by the Congress. And of course, several cases that are being decided on the Supreme Court, like Volvo, recently solved after 20 years of disputes regarding the principle of non-discrimination, or even as this one recently by dispute in the Supreme Court regarding the enforced investment of income in Brazil, and the debate regarding the tax transfer and this 1 million, and let's say 1.618.897, and all international treaty cases that were being debated. In fact, either they went through the CARF and then to courts, or directly to courts. Anyway, I think the time lapse on the debate of these debates, more than 10, 20 years of debate, in fact, today goes against the legal certainty and for previsibility of these cases. So that we understand that tax arbitrage and tax transaction, other ways to disputes resolution are very important for the advancements we intend to have, giving speed and improvement, improving the business environment in Brazil. Thank you very much.
Thank you, Professor Heleno. Excellent talk. We have a scenario of the arbitrage, how is it being dwelt in other countries as well, and the bill of that are being dwelt in Brazil, the bills. And so to deal with the subject concerning arbitrage, how it's seen today in Brazil, what's being studied in Brazil, I'll pass the floor to Professor Tathiane to talk about it, the situation in Brazil and the comparison with other countries as well. Thank you, Vanessa. Good afternoon to everyone in the assistance. Initially, I thank for the invitation via Professor Luiz Eduardo Schwer and Luiz Flávio Neto. I also greet the members of this table, Professor Ayres Barreto, our president, Professor Misabel Derzi, excellent presentation, Professor Heleno Torres, that studies a lot about the theme, and Professor Alexandre Monteiro, that's also part of this table, and the contributions will be very relevant. As Vanessa has said, my objective is to focus on the institutional environment to start modeling of arbitrage in Brazil. As Professor Heleno has explained very clear, it's important to consider arbitrage, taxation arbitrage in Brazil internally, not only due to issues of the excess in the judicial branch. When you talk about arbitrage, that's the first thing people place. But we also have international issues that are at stake that have to be considered. There are recommendations of OECD about it. Okay, when you foresee the possibility of arbitrage, you have to have it in Brazil and other countries, but we have to have the mechanism instituted domestically as well. As Professor Isabel said in her talk, there are some challenges that have to be faced in order to reach the establishment of taxation arbitrage in this country to overcome eventual issues that can place this model into check in order to have an efficiency in the modeling that is accepted by everyone. That's what we expect initially. And so the objective of my brief talk, I believe then we have some debate, it's presenting you the model of arbitrage, taxation arbitrage that has been successful internally, and after that, present the challenges in Brazil to establish the same model with a correlation with the bills that are being considered in the Senate. I won't go farther because we deal with that in the debate. What's the model that's successful? I'll use here the example of Portugal, as Professor Heleno has indicated, a very good discussion with the arbitrage center in Portugal. That is no doubt an example for us. Taxation arbitrage, successful one with academia intervention. And I would like to bring here this experience in order to do this correlation with Brazil. After that, we initially looked at the Portuguese model, bearing in mind that arbitrage, taxation arbitrage in Portugal was established in a context, economic context and financial context similar to ours today. Of course, when I said it 1 year ago, we had a different scenario. After the pandemic situation, we have a higher taxation and economic crisis. So we've been pushed by the situation of the pandemic. So when it was established in Portugal, the idea was making possible the expansion of access to jurisdiction when you when we talk about dispute in taxation, and also making possible a method that will be more efficient to concerning public income to the government, Portuguese government that I say. So in this context, arbitrage is established in Portugal in this context, and the idea of obtaining more income and expansion of access to jurisdiction, this context helped the design of arbitrage in Portugal. How was it? Initially, it's important to say that in Portugal, they have a regime that is considered a right of the taxpayers. There, the agency that's called taxation authority has rules, and the possibility exists, and it's been published. A document has been published, a notice. So it's an administrative act that refers to the subjects that the taxation authority agrees with in terms of arbitration. It refers to taxation, of course, and to values. So causes that involve up to 10 million euros. That's the agency, the taxation authority that determines that. So if there is an arbitration, the authority cannot be against it because due to the rule that has been established, it's based on the autonomy, on will. So this model shows that the objective is bringing more income to the state, but also giving possibility to have access to the judicial courts. And so it does not refer to big cases. When you consider what is happening there since 2011, and now we are in 2020, there are many discussions with low value that are taken to the arbitrage court. So you have the expansion of a democratic cases that are considered by the rule of law. So in this case, there it's called liquidation. And so there is a legal relation constituted, established, so the taxpayer considers the income and decides if they want to do the arbitrage concerning this dispute. In the Portuguese regime, it's important to say that there it's done, the arbitrage is done in the administration center. They have an administration center for it. It's not a public entity, no. It's private, but it is bound to Ministry of Justice. And therefore, there is legitimacy of the taxation authority. In Brazil, if we are not confident concerning the arbitration judges, do they defend the interest of the excise? No, it's a judge. So the structure that Portugal has, there is a list, there is a preparation to be an arbiter, and it's controlled by a council. And there is a former ministry ahead of it. A minister controls it. So it's legitimate. So it's very strong in terms of arbitration in Portugal, concerning the taxation authorities and concerning the establishment per se. But there is a point that is a conflict with our model. Despite we have the possibility of bringing taxation causes to Portugal, there is a possibility of an appeal in case the award is in conflict with a certain constitutional clause. So nationally speaking, the adhesion to this type of regime in Brazil, the model that we have already established in arbitrage, the law 9397 of 96, it's definite. The awards implies renunciation to access to the judgment. So if you have the renunciation to the access to jurisdiction, it is a word. The, in fact, the arbiter is a judge, in fact and right. So if it's a decision, it's our word that is done via arbitration in a system like us that is based on constitution as a whole, how can I guarantee that I have certainty of the rights of the taxpayers? So I won't have possibility of having access to the judicial aspect if the award is already final. So in this sense, the Bill 4468 of 2020, mentioned by Professor Torres, presents a solution that's very interesting. In case the cause involves the Constitution, they cannot be in arbitration. What's submitted to arbitration exclusively matters that are factum. So, for instance, a certain product This debate will be in arbitrage concerning legal matters, interpretation of constitution will not be subject to arbitration. It's very interesting because in our legal system, we have the taxation law in the constitution. So in fact, referring to what Professor Misabel has said, there is a hurdle here of incorporating this type of procedures in taxation law if the arbitration could decide with this final decision about a matter of taxation based on constitutional aspects. So it refers to the delimitation of what can be arbitrated or not. A second challenge that we mentioned before is the choice of the judges, the arbiters. You have to be very specific about it. It has to refer to a list of judges that we are confident about. They will be part of the arbitration courts to solve this type of issue, and it has a relation with another challenge. We have several chambers, arbitration chambers in Brazil. So why having a new agency bound to administration? We can use the chambers we already have, but it's important to see if there is some accreditation. So you assecurate you are sure of the security. In Brazil, there is some specific alteration in arbitration rules, but there are controversies about the application of it. In fact, there is no full observance of this principle, and it is important. I believe that accreditation would be very important to have legal safety. And just to wrap up, my time is over, or partly over. It's important to view and consider the legislative instrument to establish the arbitration in Brazil in terms of procedure. We have in national senate, we have bills that are via ordinary rules because it's processual. There is no need to have a complementary, supplementary law, but we have to be careful if we have to use the national taxation code. In case we have to alter the Article 151 of due to the procedure that is arbitration. So none of the bills that we have demand this alteration because the first one last year of Anastasia foresees arbitration in a fiscal process with guarantee. So this project that was presented recently in 2020, it sees and foresees arbitration before the taxation launching. So it's not a question of tributary or taxation credit. Uh, and so it's not a case of tax auditing. So it's very extensive view that we have in 152 article concerning taxation, it can be understood like a word, arbitration award. And I believe it is possible because with the civil code, there is equivalence that with the decision that is in the arbitral court. What I would like, or chambers, what I would like to leave as my final message is that we have to progress in this cause. And why? Because the conditioning of the judicial court, I have repeated constantly, this is a point that is contingential. We don't have to look for other answers because we have too many demands. So concerning tax dispute, we have to adequate to the demands, and it's a contingency. We have to have arbitration in tax, and we have to broaden our access In the case of having the necessity to adapt in Brazil, the international demands that are imposed. So if the treaty that is controlled in terms of taxes, if we have to use arbitrage to concerning disputes, we have to have everything consolidated, foreseeing all the guarantees in our internal law. What we have going on, the debate is present and the discussion is here to stay. There is no way out, and I hope that we go ahead in this sense, and no doubt this type of debate helps shedding light in these controversies in order we go ahead in an arbitration regime that is solid and safe for both parties. I thank you very much, and I'm here for the debate.
Thank you, Professor Tathiane. I think you gave us a good view of a well-succeeded experience of Portugal, and we can use for Brazil regarding arbitrage. Before passing the floor to Alexandre, we will have a quiz showed on the screen, and by the end of the panel, we will show the results. Now, thank you for the excellent lecture by Professor Tathiane. I pass the floor to Alexandre for the last talk in this first round. How the dispute is in the agreements of double taxation agreements, a bit talk about MAP and if arbitrage is included. So, Professor Alexandre, you have the floor. Thank you, Vanessa, for the presentation, the link for the presentation that will follow. First, I will start to share my PowerPoint. First, I would like to say it's an honor to be part of this panel, together with well-known, renowned authorities on the subject. So I'm honored to be here with you, ladies and gentlemen. And so I would like to thank the organizers of this event, Professor Neto, that was from the previous panel, Professor Schweri, and Rodrigo Maio. So with no further ado, our, I would like to center my lecture on debate regarding the mechanism to avoid double taxation for dispute resolution with to I start with the MAP, Mutual Agreement Procedure. Professor Heleno started very well to talk about the subject, and I will divide.
Então, acho que o primeiro ponto aqui é fazer uma...
So, the first point, it's to divide the types of mutual agreement procedures. We talk a lot about it. One in strict sense. But the third paragraph, Article 25 of the OECD model, you can interpret and integrate it. So interpretative model, integrative model, and the ways you can interpret specific terms to avoid double taxation agreements, and the integrative part, which is the final one of the Article 25.3 of OECD regarding the integration of any provisions that might by lapse were not negotiated among treaties. Professor Heleno made an exception, very pertinent. It's a classical work regarding international taxation, which is to say that obviously this integration cannot be absolute. It has to abide by the federal constitution with a specific procedure. The matter was not addressed. Regarding prophylactic mechanism, you have the interpretative and integrative mechanism on third paragraph of Article 25. Amicable procedure, stricto sensus, Professor Misabel showed the backwards you use one underway, dispute underway. This is the case for amicable procedures stricto sensus, and especially paragraphs 1 and 2 of Article 25. And basically, the basic part of this provision, someone the definition of the specific treaty, might present a case for the state, for the resident or national state, if you're dealing specifically of non-discrimination matter, as Professor Heleno mentioned, non-discrimination matter. This will that the remedies you can take for agreement when one or two states result or might result in a non-conformity dispute with the specific convention that is being dealt with. On the OECD model, we have a limit of 3 years from the first notification where you configure the problem or the threat. So, according to OECD, you have an unilateral mechanism submitted the request by the taxpayer if the state that was received this request. If it not so, it should action the second state to start a bilateral procedure. Any solution that reaches this scope should be implemented regardless any deadline according to the domestic legislation. Important to say, and it was addressed by Professor Heleno and other lecturers, the importance of BEPS for the development and use of mechanisms for dispute resolution and the DTS. So back then, the we had the UMAP with best practices, MIMAP at the OECD. So this was speeding up in the PEP's world. And it was three pillars: the good faith and celerity first objective, the second objective, development of internal administrative procedures. This is clear according to Tathiane talk. It's important to have them and to talk with these ways of international dispute resolution and also effective access by taxpayers. Professor Misabel addressed this so clear, and scholars addressed this. Recently, at the beginning of BEPS Action 15, we talked about arbitrage, and then it lost momentum. Now, recently, not only BEPS, OECD, and UN, it starts to talk about arbitrage as a supplementary mechanism for the amicable procedure, and even it said as the minimum standard. BEPS Action 14. They talk about the Professor Natalia Quinones also addressed this so well. Important to say that Brazil, we have it for a long time, the amicable procedure. All Brazilian treaties, 35 approximately, they have some variation of the provision. Something is omitted or here and there, but it's normal. But we have this for a long time, and there's familiarity regarding this. And recently, after PEPS, Professor Heleno addressed it so well. Domestically, the addition done Rule 16.6 now, and now we have the 1846 currently effective and in force. So they will bring the rules who and how may request an MIP under the specific agreement, how to amend an initial map request, rules on admission on first and second stages map, unilateral and bilateral, and ways of implementation of the award. Interesting to say that within BEPS, what was addressed is peer-to-peer review monitoring, generating a report related to Brazil, illustrating what Professor Heleno mentioned. Until 2016, we had no efficacy. As of 2016, it increases 2018 furthermore. Notice on the lower chart, first this point, we have cases of amicable procedures. We have closed cases, 6 in fact, but cases have increased, map more and more frequent its use, and celerity higher than resolution of cases corresponding. So the preliminary phase, you can see here in the charts. Also, this report showed those cases of in inventory, most cases is regarding tax allocation cases, 55.4%, 44% of the cases of the closed one, three with the elimination of double taxation, two on bilateral phase and one unilateral outcome that was not specifically recorded, and the existence of taxpayer. In one case, we understood there was no violation of a provision of the double taxation agreement. Conclusions of this report are very interesting. Regarding minimum standards adoption by Brazil, we have the fact that 80% of our treaties neither have the Article 25 second sentence, regardless of any time limits internally, nor Article 9 correlative adjustments and other subjects for this to move forward together. Notice regarding relative adjustments of transfer pricing, the inclusion of Article 9, APAs, in spite of having their 1846 normative ruling, but we don't have it internally. We have the normative instruction RAFB 1846, like it is reasonable to achieve goals. And 51% of our DDTs do not have integrative map. It's an attention point. Few treaties, 20%, have a filing deadline equal to OECD model text within 3 years. Some two, five others don't mention any deadline. Important this point. And who can request map phase? We need some improvement because many treaties, the wording is old, just the state of residence is mentioned, and they don't talk about nationality and need the last recommendation, which is the possibility of taxpayers action to action both contracting states. I think the 1846 normative instruction is seen as reasonable, although it is placed that the resolution average the timing to end case already more than 24 months. So new cases. So we have 26.33 months, which evidences the diagnosis of OECD or resources financially and so forth. So this is a point of attention. On an overall map, has been seen as a good mechanism in spite of some deficiencies. Some here listed: no obligation to reach an agreement, no time for this, no specific timing to solve issues. Some countries impose limitation of efficiency, difficulty to information about map, and in the past, today less, these provisions were used as a political negotiation, so global agreements were made among states. Just the apportion of tax burden, forgetting that the taxpayer is in the middle of this, that we call package deals or horse tradings. Additionally, it was addressed by Professor Tathiane, the need to fit for use these mechanisms to the Brazilian tax code. So we do not suspend enforceability to levy during the discussion. And another thing would be to think about any amendments in this sense or changes. To wrap up, I know we have a short time. Try to bring the development of arbitrage in this scenario, post ending of amicable decision. It was talk, voluntary arbitrage of USA and Mexico, and proved that voluntary arbitrage had no efficacy, no cases in this sense. So one or other state use an arbitrage would not move forward. So based on it, we started to study binding arbitrage, compulsory. So the map was debated in 24 months. So Professor Heleno mentioned it. So it was advancing this uh, environment, BEPS, and it's mandatory arbitrage. So ostensibly commending this, and the most advanced one, if we see North American Model Convention, recently after 2016, several provisions regarding arbitrage and bringing the in-house domestic experience of these countries. So, how does it work? Taxpayers can request to store it after so without a statutory conclusion. This arbitrage could it be institutional? Important to talk of Professora Tathiane, but within the OECD, it's seen as a ad hoc arbitrage. Each state, contracting state, will appoint an judge, and in the appointed chairman and president, it's similar to the domestic arbitrage independent opinion. Each country will present its reasoning, and the judge will present it. And this model changed a bit, and we start talking more about last best off, last best offer, baseball arbitrage. Countries presenting their option until so the arbitrator will choose the more reasonable because it starts that it's baseball arbitration because it started in USA regarding the players of baseball syndicates. So that's why the name. Depending on the type of arbitrage, we have specific time, but if it's counted as of the appointment of the chairman, arbitrage is compulsory, binding. So also it's a point to be debated if this is the best format because it can be expensive and might not be accepted by taxpayers. And in this case, to do something different, you would need to bring more safe harbors, and participation by taxpayers have to be more because the, it's a part to the case, so it will affect the assets of the taxpayers. So this would be a point that might have some development in this sense and implementation regardless of any limits, domestic limits regarding its legislation. This was basically what I wanted to say in terms of landscape, of mechanism for dispute solution. If Vanessa allow me, the first point for debate, we talked about arbitrage, interesting, efficient, valid. If the clause was worth implementing, do you think? Why Brazil does not consider including the arbitration and DTTS? Is there any point of sovereignty under debate? And I start to say that I think it would be regarding the efficiency, very important regarding sovereignty. Especially what I see is that sovereignty is no longer seen as something isolated. It's part of a bigger scenario. So some states they waive the right of their tax sovereignty when they negotiate an agreement. If you waive one of the sides of your sovereignty on the external phase to negotiate an agreement, why not admit that states that do this could not decide the way by which they solve disputes within this field? With this food for thought, I pass the floor to Vanessa. Thank you, Vanessa. Thank you very much, Alexandre. What you said, it was excellent. Wide landscape of map peer review issue, which subject to the control by its peers. So I think this question is very important for our debate. Why Brazil did not include developing countries do not include in double taxation agreements this clause. Now I pass the floor to our chairman, Paulo Ayres, for final remarks and then debates.
Okay. After all the talks that fundamentally, due to time constraint, we have 9 minutes to close this panel. So I will leave this subject open and suggest that circumstance of Brazil concerning tax law is based on constitution, so it makes more difficult the situation concerning matter that deals to law specifically and matters that due to arbitration have difficulties here. Now I pass the floor, following the order of the list. Professor Misabel was the first to present the talk. So time we have 3 minutes, some seconds to talk about this issue. Very briefly. Concerning arbitrage, that's the focus. I believe that the same problems we have not to adopt arbitrage internationally, domestically, it's the same thing. When we see and we win in terms of security and confidence, we will be closer to adopt arbitrage internationally as well. I would like to point that, yes, we have a problem, a conflict, the solutions are very slow, and there it presents in every sector, including tax. But we have to be attentive to quality of the system that is very complex, the judicial national scenario. Countries that are developed also have this problem. So in our constitution, any decision, judicial decision, has to be well fundamented. Secondly, we have equity issues, and we have to observe the precedent situation horizontally and vertically in binding aspects. We see what happens in Europe, the United States. They have oral decisions. They have awards that are presented orally. They are not published. And we also have decisions that are published, everybody's aware of, but they have a clause saying it's published, but it's prohibition, there is prohibition to evoke the precedent. So countries that have this aspect in their daily affairs, they adopt arbitrage so easily. For us, it's a quality in our system. I would like to go forward with this. In other countries, so we would like OECD to take care of it because it's a benefit to all. We observe the precedents and we require that the arbiters are consistent and coherent. So every decision will be not a sole one and contradictory. We should continue with a solution that cannot be unique and sole, because it has a complex with uncertainty involved. So thank you very much. That was my opinion. Professor Heleno Torres. Okay. I mirror Professora Misabel, she's a wonderful person, and professors. I mirror your thoughts. And we are crossing cultures here. A culture that is legalist, formalist. We're going to a space where we note that formalisms of the processes administration wants are not enough to be objective concerning pacification, social pacification between taxpayers and excise. So many times the judicial decision is favored to excise, but it's not the interest of the agency. It does not change anything effectively because the conflict exists and remains. You solve with the one taxpayer, but not with all. So looking for controversy solutions, Professor Ayres has mentioned very well in the beginning of his talk, we have the reality, an excess of conflict, systemically speaking, that's very high. Solution will be with legal systems, order, and with changes concerning administration process, judicial process, and new solutions in the conflict. So this tax reform starts where we did not expect to introducing law that is tax transaction. So this bill and the law 13988 of 2020, it is the big cross of this century. In fact, we worked hard for it, for convincing that the methods are essential. We start with the reform of the process in tax reform. So that's why we have this transaction tax law. And so what we are doing now in terms of arbitration with the discussion, it started with Anastasia, the senator, and the procedure is more determinate. The other one, the bill that was prepared with the contribution of Professor Selman, myself, and Cida Paricelli, we construed a text that I believe it is not involving or reaching or hurting the administration regime or the tax transaction, starting a new phase, prevention, to avoid conflict, deciding about matters, facts and the rights being decided in the previous phase, before the construction of the tax budget. If we have discussions so simple like what kind of shoe is this? Is this considered food? No element all over the world. The judges will never find a solution for everything. Imagine the high courts have a judge asked to decide concerning types of shoes, concerning physical, chemical aspects of shoes, for instance. So many things. We know the sectors like telecommunication, power, electric power. Okay, never mind the auditor, how knowledgeable he or she is. There is no definition solution. Uh, but a solution has to be found. So let's put aside this model, the belief that there is absolutism in the judicial courts. Of course, it's binding decision, but it's not the peaceful one. It's not the one that will give serenity and tranquility to the tax holders, the taxpayers. So this debate is very important. As Tathiane has said very well, experience of Portugal is an example for us. It's a fantastic experience. Exactly in this line, as Alexandre has pointed out very well, in this formation of methods, composition with the international treaties will generate safety, forecastability. So people that will invest in Brazil know how we do and how we construct and how we interpret the how we understand the treaties. When we apply, there are doubts, and any decision and the judicial process cannot last 10, 20 years, like it was the case of VOP that started in 2098. So it's alarming, it's scaring situations like that. And it's not normal. It's not to be accepted. A process that lasts 22 years a case and that will go to the Supreme Court. Things like that are shocking. And we do not want anything like that. All the talks converge to the same point in every sense. The importance of this methodology, necessity of affirming via BEPS 14, and with these new models, there is a change of cultures in the revenue, in the excise. If you have the introduction in the constitution in Brazil, in law in Brazil, so the consequence naturally will be the incorporation of the treaties to avoid double taxation with specific costs involving arbitration. And I believe that this uh, change of tax transaction, it will change, of course, with the assessment of the auditors in excise and revenue concerning this subject, tax and arbitrage. Thank you, colleagues. Congratulations for the panel, Vanessa. Now, very quickly, Professor Tathiane. I, I won't add anything. I'll use 1 minute only, just to give an opinion concerning Professor Heleno's comment about the delay in our judiciary courts concerning arbitrage. It lasts, the process lasts around 4 months and a half. If it's lengthy, it's 1 year. Of course, in Brazil, it's completely different from Portugal in terms of size, but we can have it briefer with legal safety and according to international procedures and constitutional procedures. Thank you again. The debate was excellent. Thank you. Now, thank you for your time. Alexandre, final considerations. Okay, I believe that there's not much to say. I believe that everybody has been placed have the same thought and environment that we have is litigation. It's a conflictual scenario when it involves the taxpayers. Governance per se brings this with another bias. But concerning controversies, in fact, it's so necessary. Another point that we have to place, we are trying highly to be part of the OECD, and arbitrage there is being indicated. It's already in the convention, if I'm not mistaken, fourth or fifth article, and BEPS as well. So it will be a minimum standard. And in the beginning of the discussion concerning international arbitrage, and nowadays there is a big progress. And in the beginning of the discussions in Action 14, now it's very significant, the scenario of arbitrage. Some years ago was totally hard to admit. In this moment, it's more visible for those that deal with difficulties in the area, mainly in the international tax law. So with that, I wrap up, and I thank you all for the excellent level of the panel. So I thank you on behalf of IBDT, the professors for your contribution and presence, all of you named here. So it was an excellent talk. Thank you all.
Obrigada, professor Paulo. Uma boa tarde.
Thank you, Professor Paulo, and good afternoon.